please share this video and the links above or below it far and wide, because it gives crystal clear examples of the Crown Prosecution Service and the police massively failing in their disclosure duties, and also when confronted with that in writing, doing everything they can to avoid addressing the fact they failed in their disclosure duties and the fact that they failed in them since, well, for decades now. All is explained at the links above or below this video and also in the video that follows. Please do share this far and wide. The point is that the police and CPS wrote to each other in 1994 after a case collapsed due to the lies of Rupert Murdoch's fake Sheikh Mazher Mahmood, and stated that he could not and should not ever be relied upon as a witness of truth ever again. More cases collapsed over the coming years, in fact over the coming decades, until the collapse of the Talisa trial in 2014, when they finally stopped relying on his evidence. Had these things been disclosed to me before my 1999 fake Sheik related trial, then I would never have changed my plea from not guilty to guilty rather on the first day of trial, because I would have been able to show that Mahmood was a serial liar and fabricator and mess with evidence and such like, as he did, as illustrated at the links above or below this video in my case. Take a look at what follows. So for the record, on the 13th of November 2025, I sent an email to the Crown Prosecution Service and various departments of them, which basically, I'm going to scroll down, said, "Dear Sir and Madam, on the 11th of March 2025, I emailed you and posted, tagging people on all major social media platforms, the open letter which appears at this link, and a link to an open letter that I have on the internet, asking for details of Mahmood's cases that have collapsed. To date, I've had no answer. I give the link to Paddy French's story showing all the different Mahmood cases he's been able to find that have collapsed, that the police and CPS never disclosed to me or any other victims. And I am writing to ask once again to formally request full disclosure of information, evidence and details in relation to the cases that have collapsed or been overturned due to the dishonesty and or unreliable evidence of former News of the World, Sun on Sunday and Times newspaper journalist Mazher Mahmood, aka the fake Sheik. Also, why, when the police and Crown Prosecution Service under CIPA rules have a legal obligation to disclose such to me and other Mahmood victims, have they never done so before or after my trial in 1999? Please fully consider the information at the two above links and then reply explaining why disclosure was not made to me as it should have been by the police and CPS." Now bear in mind that they get the link in there to that open letter to the public, okay, and the police and CPS, where there is a video, and it goes into details, and it makes mention of the fact that there was a case in 1994 that collapsed, a case in 1998, 99 and others that they never disclosed to me, okay. So I also gave them the link to Paddy French's article, yeah, that fake Sheik Tainted, which as you can see in that article, Paddy outlines a 1992 case, another 92 case or story, a 94 story, a 98 one. All four of them happened before my 1999 trial, and yet none of them were ever disclosed to me. And if they had been, I would never have changed my plea from not guilty to guilty on the first day of trial, because I'd been able to discredit Mahmood. But then the collapse cases go on and on and on and on, as you can see at Paddy French Substack, okay, Murdoch's fake Sheik Tainted. Do they answer these questions? Well, an email came today, 19th of November. "Dear Mr. Smith, thank you for your recent correspondence. Upon full consideration of the matters raised, there will be no further disclosure in your case. The refusing to disclose anything. The Crown Prosecution Service may only disclose material in our possession that is relevant to the issues in the case. I would say everything that is on Paddy's page is relevant." Then they try and switch things by going, following your guilty pleas to the offences, you were sentenced and subsequently sought leave to appeal the conviction. Paragraph 23 of the appeal judgment, 21st of January 22, Lady Justice Carr said as follows. In any event, a continuing theme of the application, namely that in some way Mr Mahmood's dishonesty would have been relevant to and or have given rise to a material basis for an application to stay, simply does not make any sense, as the single judge said below. Whether or not Mr Mahmood was dishonest was nothing to do with the issue. The issues in this case were whether or not the applicant knew that he was handing over counterfeit coins. That was something which he was preeminently in a position to know himself and unaffected by any dishonesty on the part of Mr Mahmood. Well, that is what she said, but it's completely misguided and wrong. Anyway, they go on to say, when entering guilty pleas, you accepted knowledge that you were handing over counterfeit coins. No, I wasn't. I was basically pleading guilty because I'd been given bad advice and told that Mahmood wouldn't have to reveal any of his sources, which he wouldn't have been able to do anyway because the source was me. The Court of Appeal has already considered the safety of your conviction and determined that material relating to Mahmood's honesty in other proceedings was not relevant, nor would have given rise to an application to stay. Trust this clarifies why there will be no further disclosure in your case. No, it doesn't, which is why I've responded with, Dear CPS, with the greatest of respect, that is nonsense and you know it. You at the Crown Prosecution Service, along with the police, seriously failed in your disclosure duties to me prior to me changing my plea from not guilty to guilty with mitigating circumstances on the first day of trial in 1999 after receiving what I now know to be bad advice. Had the CPS disclosed the cases that had collapsed before my case was due to go to trial due to Mazher Mahmood's lies and dishonesty, then I would never have had to change my plea to guilty and would have been able to show that Mahmood was and is a serial liar. I then put the link again to Paddy French's Murdoch's Fake Sheik Tainted article. See above link for details of collapsed cases that I am now aware of that you have never disclosed to me at any time as you are obliged to under CPIA rules. As for what Lady Justice Carr said in January 22, since then I have won legal action against Newsgroup newspapers, which was filed on 30th of September 22, and Newsgroup settled it at the end of 2024, giving me a written letter of apology in early 25 in Alex Smith versus NGN. And during discovery disclosure obtained videos, audios, documents, photographs, receipts and masses of other fresh evidence which strongly support my position that Mahmood acted unlawfully and that he did not tell the truth to the police or CPS in my case. Indeed, I now have proof he used phone hacking, illegal surveillance and unlawful information gathering in my case, as well as printing outright lies and tampering with evidence, among many other things he should never legally have done and did not disclose to the police or CPS that if he had my case would likely never have gone to court in the first place. In the process of reviewing all of my fresh evidence ready for resubmission to the CCRC, which I shall be doing on Tuesday the 3rd of January 2026, I have so far put this together and a bit of a draft of ideas I put together showing why my convictions are unsafe. You are invited to take a look and make comment on it. I suggest you do take a look as things have moved on massively with evidence galore having come to light since Lady Justice Carr's comments of January 22. Yours truly, Alex Smith. And that's just been sent today at 3:14 p.m. on the 19th of November 2026, 25 even, to the CPS. I suppose I shouldn't be surprised that the CPS decided, rather than holding their hands up and going, yep, we should have disclosed these things to you, that they're trying to distract from the matters at hand. But as you've seen in this video, I've now sent back to them the stuff that shows that in Alex Smith versus Newsgroup newspapers, which wasn't filed until after Justice Carr's comments. It was filed on the 30th of September 2022, settled towards the end of 2024. I got a private letter of apology early 2025, and during discovery stroke disclosure in that, I got my hands on videotapes, audio tapes, photographs, receipts, documents and evidence, fresh evidence galore, that shows that Mahmood acted in unlawful and arguably wholly illegal manners in the manipulation and fabrication of his fake story that led, due to his lies and deceptions, and in some cases his lack of disclosure, because he never told the police that he was using phone hacking or unlawful information gathering techniques. He also never told the police that I was his source. I kind of tipped him off, as is fully explained at the links above or below this video. But there are documents that have been released to me that show that that's the case. They were never given to the police, otherwise it'd probably never gone to court. So all of this has now been sent back to the CPS, as you've seen earlier in this video. See what they make of it. It's immaterial anyway, because the more you spread this video, the more the truth will get out there. And also then hopefully they'll have to sit up and pay attention when I go to the Criminal Cases Review Commission on Tuesday, the 3rd of February 2026 at 10:30 AM, which is when I'm delivering my bundle of over 4,000 pages of fresh evidence galore, showing that if I'd had the previous cases that had collapsed due to Mahmood's lies and dishonesty disclosed to me, as I should have done under the rules, the CEPA rules that the CPS and police are supposed to abide by, then if I'd been given that material disclosure, I would have been able to show that Mahmood was dishonest in court, and I would never have changed my plea from guilty to, not guilty to guilty, as I was forced to by the bad advice I got. So the fact is, watch this space.